Today we're going to talk about aggravated stalking in Georgia and some of the potential defenses to aggravated stalking, what the prosecutors must prove, as well as what the range of punishment is if someone is convicted of aggravated stalking. Aggravated stalking may not be exactly what you think it is when you hear aggravated stalking. A lot of times you may think that it's someone repeatedly driving by someone's work or home, or phone call, numerous phone calls to someone or something like that. And it's not necessarily true that that is aggravated stalking. It could be, but there are some other things that prosecutors must show. One of the first things prosecutors must show is that the contact was done in order to harass someone or in order to intimidate someone. So those are the only two types of conduct that can be done to be used to charge someone with aggravated stalking: harassing conduct or intimidating conduct. Additionally, prosecutors will have to show that that conduct was in violation of some type of order to stay away from the other person. Now that can come in numerous fashions. It can come from a protective order, a TPO, a permanent protective order. It can come as a bond condition that says, hey, have no contact with someone. It could come in the form of a bond to keep the peace. There are many different ways that someone can be ordered to stay away from someone. In Georgia, particularly the Coweta Circuit and surrounding areas, one of the most popular forms of aggravated stalking that we see is someone is arrested for a less serious crime, potentially a misdemeanor, battery, a domestic situation, or something like that. And part of their bond is, hey, you're supposed to have no contact with this other person. Well, then they'll call or reach out in some fashion to this other person, and that usually ends up resulting in them being charged with aggravated stalking. This is where one of the very common defenses to aggravated stalking comes into play, in that the prosecutors still have to show it was for the purpose of harassing or intimidation. So a common defense is that the conduct was in fact not harassing nor intimidating. And that is, like I said, one of the most popular defenses. The other thing that people are oftentimes concerned with in aggravated stalking cases is what kind of range of punishment we're looking at. What can happen if someone is convicted of aggravated stalking? The prison time itself can be, the range of punishment is 1 to 10. So if you're convicted of aggravated stalking, the sentence could be anywhere between 1 year of probation to 10 years in prison. Another thing that often happens in aggravated stalking cases is, upon conviction, a judge can order that the defendant or the person being convicted undergo psychological testing, as well as the judge can grant a permanent protective order prohibiting the defendant in that case from any future conduct with the alleged victim and her family, property, etc. So that is an overview of aggravated stalking in Georgia. Remember, you can always reach us by text message or phone call at 470-635-1725. We look forward to helping you out. Good. Sweet.
I hit the red
Yep.
thing. Okay.
Let's test it.